number 345 of 2025, Uganda vs. Kano, retired Dr. Besigye, Obedi and Captain Elisola.
Martha Karua, senior counsel, appearing for A1 and A2 alongside.
This matter was fixed for a ruling today, the presence of all parties. There is no reason given as why counsel for S3 is not in court. But since S3 is in court, court will go ahead to deliver the ruling. Here, any question as the interpretation of this constitution arises in any proceedings in the court of law other than the field of commercial, the court referred the question to the constitutional court for decision in accordance with clause 1 of the submissions above. One says that all the submissions of counsel for 1 and 8 we have put into consideration, but briefly they submitted that the article cannot be delegated anymore. That the question is whether its plain meaning the court faced with such circumstances can be, particularly for purposes of trying those people who have brought the complaint against them. Counsel contended that Article 137(5), paragraph 1, paragraph A, gives this court discretion, while paragraph B does not grant such expression, and his authorities I have cited, I am bound with the same. It is this court's opinion, therefore, that the question of law proposed and framed by counsel for the accused persons for interpretation does not involve a substantial question of law for interpretation of the Constitution. The allegation that there is a likelihood that the accused persons who complained against the trial judge for the Judicial Service Commission will not get a fair trial is an imagination, because Article 28 of the Constitution lays down all the principles of the right to a fair hearing, which court is mandated to observe and cannot be compromised by the trial judge. I have put into consideration the cases referred to by counsel for A1 and A2, that is the case of Professor Isaac Newton of York. However, it is my finding that the authorities referred to relate to the bias, not directly relate to the constitutional reference. It is my view that this court is not satisfied with the question of law framed for constitutional interpretation. In the final result, it is this court's finding that counsel for the accused person have not made out a prima facie question of law to warrant reference to the constitutional court for interpretation. I accordingly decline to refer the proposed question of law to the constitutional court, and I direct that let the matter be fixed for scheduling and free-taking the so-called.
John! Sure. We are tired! Sure.
Complaining that they were barred from coming in They had been there since 8 o'clock.
That one we shall discuss, so you can have a meeting with security. Let us pass by the post.
You people even know what is the protocol. Justice. Not the balance.
So this being a public trial, we are urging the court to order the orderlies at the front gate of this court building to let members of the...
It's okay, I will come back to that. Let me first go to the way forward of 350. I will come back to that.
Way forward, we were also going to come back to that.
Yes.
In view of your ruling, we will need to take instructions from our clients. We did not expect or know how the ruling would go. We naturally need to go and take instructions. We would also urge that the orderlies are impressed, the orderlies in court, even when removing a person who is agitated, they must not mishandle. They should handle people properly. And especially if it's a female, she should be handled with extra care, lest the handling amounts to indecency.
Why are you doing this? Where is your parent? Leave me, leave me. Every time you wasted our time for 1 whole year. 1 whole year to join so much script. Is this